There are moments in life where you can feel the weight of history in a room. For me, that room was always a courtroom. The polished wood, the stern face of the state seal, the hushed expectation of justice. It was a temple of order, of reason, or so I thought. My name is Julian Crestmont, and I've spent my life studying the law, believing in its power to bend the arc of history. But on a humid Tuesday in the Cumberland County Courthouse, I learned that for some, the law isn't a shield of justice, but a weapon of exclusion. And I was about to be reminded that I wasn't just a lawyer in that room. I was a black man. The hook wasn't a dramatic opening statement. It was a simple, dismissive flick of a wrist from a woman named Darlene Higgins. I was there for a preliminary hearing for a voter suppression case. My client, a community organizer named Isaiah Jones, was facing absurdly inflated charges for disorderly conduct and trespassing for setting up a voter registration desk in a public park. It was a blatant attempt to intimidate him and his organization. The case was small, but the principle was everything. I arrived early, my suit crisp, my case file meticulously organized. I approached the clerk's window. Darlene Higgins was a woman in her late 50s who had been working that counter for 30 years. She wore her petty authority like a crown, treating every lawyer, defendant, and citizen as an interruption to her solitaire game. Julian Crestmont for State versus Jones, I said, offering a polite smile. She didn't look up, her fingers clacking on her ancient keyboard. Bar number. I gave it to her. She squinted at the screen, then at me, her eyes performing a slow, insulting scan. They took at my skin, my tailored suit, my briefcase. I saw the familiar calculation in her gaze, the dissonance between what she saw and what she expected. Crestmont, she said, drawing out the name. Don't see many of you folks in here as attorneys. The comment hung in the air, thin and poisonous. I let it pass, a lifetime of letting it pass. The hearing is at 9, I said, my voice even. She hummed a non-committal sound and went back to her typing. After a moment, she slid a form under the glass partition. You'll need to fill out the new counsel appearance Form 121B. Recent rule change. Can't proceed without it. I glanced at the form. It was a standard sheet I'd filled out 100 times. But at the bottom was a new, glaring requirement. Asterisk must provide proof of ongoing, state bar-approved, continuing legal education credits for the current cycle. Asterisk. I have my bar card, I said, pulling out my wallet. It's all current. Not good enough, she said, a smug little smile playing on her lips. New procedure. Gotta see the CLE certificates. Physical copies. Gotta crack down on all these new attorneys trying to practice without keeping up their education. She said new, the way another person might say incompetent. The implication was clear. She decided I was a novice, unprepared, and worse, that I didn't belong. She hadn't asked a single white attorney ahead of me for this proof. I kept my composure, but the heat was rising up my neck. Ms. Higgins, my bar card is proof of my standing. This is an unnecessary hurdle. My hearing is in 15 minutes. Rules are rules, Mr. Crestmont, she said, her voice dripping with false sympathy. I don't make I just enforce them. No form, no hearing. You can reschedule. The next available slot is... Oh, looks like 6 months from now. 6 months. My client life is work, held hostage by a bigot with a stamp. I felt the eyes of the other people in the line behind me. The familiar cocktail of humiliation and rage began to simmer in my gut. That's unacceptable, I said, my voice hardening. She leaned forward, her voice dropping to a conspiratorial whisper that was somehow louder than her speaking voice. Look, son, maybe this is a bit too advanced for you. Maybe you should go find yourself a more experienced lawyer to handle this. A real one. This is a complicated case. Asterisk son. A real one. Asterisk. The temple of justice felt like a house of cards, collapsing into dust around me. All my degrees, my accolades, the respect I'd earned, it all meant nothing in the face of her ingrained prejudice. Just then, the district attorney, a man named Robert Gage, walked up to the counter. He was everything the system loved, middle-aged, white, impeccably connected. Darlene, my angel, I need the files of Patterson Appeal, he said, flashing a charming smile. Right away, Mr. Gage, she chirped, her entire demeanor transforming into one of fawning deference. She handed him the files without a single request for a form or proof of education. I saw my opening. Mr. Gage, I said, turning to him, perhaps you can clarify the new procedure. Ms. Higgins here informs me I cannot proceed without providing physical CLE certificates, a requirement she didn't mention to you. Gage looked from me to Darlene, whose face had flushed a blotchy red. He was a political animal, and he knew a lawsuit when he saw one. Oh, I'm sure it's just a misunderstanding, Julian, he said smoothly. Darlene, I think a current bar card is sufficient for Mr. Crestmont. He's one of the finest constitutional lawyers in the state. Darlene's mouth opened and closed like a fish. But the rule... Let's just process him through, shall we? Gage said, his tone leaving no room for argument. Grudgingly, with hands trembling with fury, she stamped my form and shoved it back under the glass. Courtroom 4B, she muttered, not meeting my eyes. I won the hearing that day. The judge saw the voter suppression case, the sham it was, and dismissed all charges. But the victory felt hollow. The taste of Darlene Higgins' contempt lingered. It was a reminder that the system wasn't just broken in its laws, but in its people. A month later, I was back in the same courthouse, this time for a far more significant case. I was leading a constitutional challenge to the state's newly passed voter ID law, a piece of legislation so restrictive it would have disenfranchised hundreds of thousands of elderly, poor, and minority voters. The courtroom was packed with press, activists, and state officials. And behind the clerk's desk, overseeing the filing of monumental legal briefs, was Darlene Higgins. I approached with my junior associate, a brilliant young woman named Chloe, carrying a box containing our final briefs. We were filing our motion for summary judgment, arguing the law was unconstitutional on its face. We're here to file the plaintiff's motion in asterisk Crestmont versus. The state asterisk, I said. Darlene looked up, her eyes glinting with recognition and undiminished malice. Well, if it isn't Mr. Crestmont, back so soon? Couldn't handle that last little case on your own. Chloe stiffened beside me. I placed a calming hand on the box. We need to file these, Ms. Higgins. The docket closes at noon. She peered into the box, then pulled out one of the thick briefs. She flipped it open to the first page, where the legal argument begins. My, that's a lot of big words, she said, her voice loud enough for the entire line to hear. A few people snickered. My face burned. You understand all this, do you? All this legalese? I wrote it, I said, my voice dangerously low. I'm sure you did, she said, with a wink to the person behind me. I'm sure you and your little helper here worked real hard on it. She patted Chloe's arm condescendingly. Chloe looked like she'd been slapped. Darlene then picked up the brief and made a show of slowly, painfully, reading the first few lines aloud, mispronouncing every other term. A petition for a writ of mandamus? What in the world is that? Sounds like some kind of fancy coffee. She laughed at her own joke, a harsh, cackling sound. This was different from the last time. This wasn't a private humiliation. It was a public spectacle. She was mocking not just me, but the law itself. The motion cites the new state constitution amendment 14. I said, cutting through a performance. The voter protection amendment is directly on point. She stopped laughing and squinted at the document, then waved a dismissive hand. Oh, that silly thing. I heard about that. Some feel-good measure that got voted in. Doesn't mean anything. Not like the real Constitution. She leaned forward, her voice dropping into that same faux confidential tone. Let me give you some free advice, Mr. Crestmont. You're wasting your time and the court's time. These people you're representing, they don't understand all this. They don't need all these complications. And you, with your fancy argument about amendments nobody's ever heard of, you're just an over your head. She finally took the box and slapped a filing stamp on our cover sheet with unnecessary force. There, all filed. Good luck with your little project. We turned and walked away. Chloe was shaking with rage. I can't believe she spoke to you like that. To us. Who does she think she is? I didn't answer. I was somewhere else entirely. Her words had unlocked a door in my memory, a door to a stuffy library corral, and late nights filled with coffee and a profound sense of purpose. The day of the hearing arrived. The main courtroom was packed to the rafters. State legislators who had passed the voter ID law sat smugly on one side. My clients, a coalition of civil rights groups, sat on the other. The air was thick with anticipation. Judge Irene Watkins, a stern, no-nonsense jurist, took the bench. "Counselor Crestmont," she said, "you may begin your argument." I stood, my notes untouched on the podium. I began to walk the court through the history of voter suppression in our state, the intent behind the new law, and its disparate impact. The state's attorney, a slick lawyer named Morrison, objected constantly, trying to throw me off rhythm. But I was steady. I built my case, brick by brick. Finally, I reached my climax. "And so, Your Honor, the state's law is not merely unwise or unfair. It is unconstitutional. It violates the most fundamental right in a democracy, the right to have your voice heard. It violates the clear, unequivocal language of our state's highest legal document." Morrison jumped to his feet. "Objection, Your Honor. Counsel is misstating the law. The state constitution grants the legislature plenary power to regulate elections. There is no such clear, unequivocal language prohibiting this law." Judge Watkins peered down at me. "Mr. Crestmont, your response." This was it, the moment the entire case turned on. I picked up a single, thin document from my table. It was different from our thick legal briefs. It was printed on older, slightly yellowed paper. "With the court's permission," I said, my voice resonating to the silent room, "I would like to read into the record the specific language I am referring to." I began to read. Section 14, Article 1. "The right of every qualified citizen of the state to vote shall be deemed fundamental. No law shall be enacted which unnecessarily burdens, restricts, or qualifies this right for any citizen. The legislature shall have the power to enact laws to ensure the integrity of elections, provided that no such law shall have the effect of denying or abridging the fundamental right to vote based on race, socioeconomic status, or geographic location." Asterisk. The words hung in the air, plain and powerful. Morrison scoffed. "Your Honor, that's not in the state constitution. Counsel is citing to some draft, some law review article. It's a fabrication." From the clerk's table, where Darlene Higgins was dutifully taking notes, I heard a distinct, smug sniff. She shot me a look that said, "I told you were in over your head." Judge Watkins was frowning, turning to her own copy of the state constitution. "Mr. Crestmont, I am not familiar with this section. Can you provide a citation?" I looked directly at Darlene Higgins. My gaze was a laser. The entire courtroom followed my line of sight. She shifted uncomfortably in her seat. "I can, Your Honor," I said, my voice calm and clear. "It is State Constitution Amendment 14, ratified by 68% of the voters in the last general election. It is the law of the state." "It is not," Morrison insisted. "I have the Constitution right here." He held up his own thick, leather-bound volume. "Then you have an outdated copy, Counselor," I said. I held up my single, printed page. This is the official text. The amendment was popularly known as the Voter Protection Act, but its formal legal title, the one I wrote when I drafted in law school 15 years ago, is the Crestmont Amendment. The silence in the courtroom was absolute. You could have heard a dust mite breathe. Judge Watkins's eyes widened in recognition. The Crestmont Amendment. Of course. I remember the case law now. You drafted this. "I did, Your Honor," I said, "as a law student, working with the Brennan Center for Justice. It was my thesis. We gathered the signatures. We ran the campaign. The people of this state passed it into law. It is, without question, the supreme law of the state." I turned my body now, fully facing the clerk's table. My eyes locked with Darlene Higgins. Her face was a frozen mask of horror. The blood had drained from it, leaving her a ghastly shade of pale. The pen she was holding slipped from her fingers and clattered onto the floor. The sound echoed in the silent room. So, when I cited the amendment to court clerk during filing, I continued, my voice dropping, but every syllable piercing the silence. And she told me it was a silly thing and didn't mean anything. She was not only mocking me, she was mocking the will of the people of this state. She was dismissing the very Constitution she has sworn to uphold. I let that hang in the air for a long, long moment. The humiliation I had felt was now reflected back at her 1,000-fold, amplified by the gaze of a packed courtroom, a judge, and the rolling cameras of the press. Judge Watkins found her voice. It was cold as steel. The objection is overruled. The court takes judicial notice of Amendment 14. Mr. Crestmont, please continue. I didn't need to continue. The case was over. We won, after the judge slammed her gavel, declaring the voter ID law unconstitutional. The courtroom erupted. My clients hugged me. The press swarmed. But through the crowd, I saw Darlene Higgins, frantically gathering her things, trying to flee. I made my way over to her. She flinched as I approached. "Ms. Higgins." I said, my voice not loud but clear. She couldn't look at me. I didn't know. That's the point, isn't it? I said, you never do. You look at a person and you think you know their story, their worth, their intellect. You saw a black lawyer and assumed incompetence. You never once considered that the man you were mocking, the man you called son, was the architect of the very law that protects the rights of every person in this room. Tears were streaming down her face now, tears of shame and terror. She was ruined, and she knew it. I could have you fired for this, I said quietly. I could sue the county for discrimination, and believe me, I am considering it. She looked up, her eyes pleading. But I won't, I said. Not if you do one thing. Anything, she whispered. From this day forward, I said, you will treat every person who comes to your window with the same respect you gave a district attorney. The single mother fighting an eviction, the kid with a public defender, the immigrant filing paperwork. You will see them not as interruptions, but as people seeking justice in a system that is already stacked against them. Because you never know. The next person you mock might have written the rules you live by. I turned and walked away, leaving her standing there, shattered in the temple of justice she had defiled. The amendment was more than a piece of paper. It was a promise. And that day, it was also a mirror held up to a woman who finally had to see her own reflection, and to a system that was forced to live up to its own ideals. I walked out of the courthouse, the weight of history no longer a burden on my shoulders, but a tool in my hands. Subscribe for more intense social justice stories and real-world inspired dramas. Like, comment, and share to amplify the fight against racial profiling. Hit the bell for updates on stories that expose injustice and inspire change. The end.